609DS. Do we have the parties on that matter present?
Yes, Your Honor.
Yes, Your Honor.
Okay. Do either one of you have attorneys anymore representing you or not?
No.
No, Your Honor.
Okay. So this was a parenting time violation that had been adjourned out due to the fact that you were scheduled to have a hearing before the judge. Looks like that hearing has happened. And the recommended order was put into place that it looks like by the judge. And that gives, I believe, Mr. Harding, what, standard parenting time? Is that correct?
Yes, Your Honor.
So, sir, these parenting time violations are for things that happened at what time frame?
From July 15th to, I want to say, September. It was like a month later.
Okay.
It was like a month and a half before I got to see my kid again. And the only time I got to see that is when I filled out that paperwork and I got it. And I had to send that to her in a picture text before. She even agreed to let me start seeing my kid again.
All right, and I think we addressed, because our hearing was in August, I know we addressed some of that information then.
Yes.
In the next. Okay. So since this new order's been put into place, has there been any violations or any issues, sir?
There's been a couple of issues, but like not severe. I get like I got emotions, stuff happened in court, and it's just figuring out the communicational level from here.
Okay.
This is where we both just struggle at. And
all right, Ms. Lauber, anything that you wish to say?
He's been getting parenting time. On the 25th of September, I filed an ex parte motion with the judge, and he granted that we follow your recommendation until we went to court. Then we went to court, and he granted what you recommended.
Okay. All right, and then so again, Mr. Harding, your issues relate to that time frame, not since that new order has been put in place. Is that correct?
yes.
Okay. All right. Well, given the status of this matter, we did have that hearing back in August. Some of these issues were addressed. There was a new recommended order put in place. That order was upheld. So given that status, I am going to dismiss the show cause. Obviously, Mr. Harding, if that new order that's in place now gets violated, you're free to file any violations related to that new order. Okay.
Yep. Perfectly fine.
All right. Thank you both for appearing. You're all set and can sign off.
Your Honor, is that for both of them? He filed 2 different complaints.
Yes.
Okay, I was just clarifying.
Any prior complaints? Yes. So anything
right.
new, we would address new, but those prior complaints are dismissed.
All right, thank you.
Yes, Your Honor.
Yes, Your Honor.
Okay. You're here today on a alleged parenting time violation against Miss St. Clair. I know the parties also have a hearing coming up on a custody motion, March 17th. So, Mr. St. Clair, you're alleging that you missed some parenting time. Is that correct?
That is correct, Your Honor.
Okay. All right. I think what is appropriate then is to take testimony in an evidentiary hearing on that matter. We fortunately have that other court date set on March 17th. So I will hear this matter along with that motion on March 17th. Any questions, sir?
So I won't see my kids until we have our court date on March 17th.
He's
I don't know what the two are doing or not doing. So, there's an order in place on March 17th. We'll hear if that order's been followed or not. And if it hasn't been followed, why it hasn't been followed. And I'll make decisions on that time.
Your Honor, he's been offered parenting time. He just hasn't accepted on the grounds that I've put out for him. He's only elected to see his children once.
I'm not here today to get into the merits of all that and the presentation of evidence. We will hear this matter then on that March 17th date along with the custody motion.
Okay.
All right. Thank you both for appearing. You're all set. We'll see you March 17th.
Thank you, Your Honor.
Thank you, Your Honor.
DC, we have the parties on that matter present.
Yes, Your Honor.
Okay, we have Mr. Balmer present. Is Ms. Short present? Does not appear that Ms. Short is present. We are here today on a show cause against Mr. Balmer, alleging violations. This matter was set for 9 o'clock. It is now 9:07. Ms. Short is the complaining party. Given her failure to appear, I will dismiss the show cause.
Hey,
Any
Your
questions?
Honor, I
Yes.
got a couple questions for you, sir. This is the second time that this has happened, and this is the problem I'm having is the whole miscommunication with her. So I don't know if there's anything I need to do to file on my end, because I know she turned in some other paperwork. We got another meeting about, April 16th, I want to say, Your Honor?
Yeah, there's a hearing on it. She has a motion to modify custody on April 16th.
Yeah, so I
So
guess I'm just, go ahead.
You're always free to file your own motions regarding parenting time or custody if there are issues to address. You can get that
Okay.
paperwork from the office.
Okay, and what times are they open? The front office or front of the court?
8 to 4:30.
8 to 4:30. Okay, well, I appreciate it. I just wanted to make sure because this is the second time this has happened and there's just been a big miscommunication. So I need to, do you know what forms I actually need to go in and get, or does the friend of the court tell me what I need to explain to my situation and they'll tell me what I need to fill out?
Yes, they can give you the correct form.
All right, Your Honor. Thank you. I appreciate it.
I guess for the record, I would indicate that given her failure to appear, we can certainly look at future parenting time violations and decide what steps we take and if she gets a hearing or not.
Okay.
All right. Thank you, sir. You're all set.
Thank you, Your Honor. Have a good day.
For next call, the
Yes, I am.
you. All right, we're here today, it looks like, regarding Mr. Farnsworth's failure to attend the SMILE program. Sir, have you taken care of that matter yet?
Yes, I do have it scheduled in Calicaska on the 3rd of this upcoming month.
Okay.
I did try it last month, but I did not know that I had to pre-register for it. But I do have it signed up to be taken on the 3rd.
All right, so what I will do then is we'll adjourn this matter to a date after March 3rd, but if you do provide the proof that that's been completed, then that hearing would be dismissed.
Okay.
All right, any questions, sir?
No, Your Honor.
Ms. Fleming, any questions?
No.
All right, thank you both for appearing. You're all set and can sign off.
Thank you.
Thanks, Your Honor.
Yes, Your Honor.
Thank you.
And I'm here as well.
All right, thank you. So we're here today for a hearing regarding the failure to attend the SMILE program. I got some information that perhaps the parties have submitted a request, a stipend order of reconciliation. Is that correct?
Yes.
Yes.
Okay. So that does place the matter on hold for up to 6 months, and then perhaps dismissed. So given that status, then there's no need to pursue this current hearing. So we're not gonna adjourn to a date. We'll just simply dismiss this matter at this time. Obviously, if there's a breakdown, you guys will need to complete that program. But if not, then you're all set.
I have a quick question for you, if that's okay.
Sure.
As far as we just got something for a child support review as well from friend of the court. Is that something that's put on hold as well?
I believe it would be. Yes.
Okay. All right. Thank you.
All right, thank you. You're welcome. Both may sign off. On that matter, President.
I am, Your Honor.
Okay, Ms. Turner is present, and Mr. Blumberg, you're on behalf of Ms. Turner.
Actually, Judge, I'm here. I guess certainly can appear for this proceeding. It has to do with apparently Mr. Turner's inability to complete the SMILE program.
Correct. And does not appear that Mr. Turner is present. 1 second. Yeah. Okay. All right. It does not appear that Mr. Turner is present.
Judge, he still may be incarcerated. I don't know for sure.
Okay.
But I know that he was sentenced and was spending some time in the county jail.
All right. Well, thank you for that information. I guess what we will do is see if he is lodged. If he is not lodged, I would recommend a bench warrant in the amount of $200, which includes $100 for costs. If he is lodged, then we will have to set the matter for a new date. I know that this is the second time he's failed to appear for this type of hearing. So we'll check that jail log. If he's there, we'll reschedule it. If he's not there, then we'll issue a bench warrant. Any questions, Mr. Blumberg?
No, Judge, thank you.
Thank you. You're all set. 684 DC. We have the parties on that matter present.
I am, Your Honor.
Thank you. You have Ms. Dork present. Mr. Roll, can you hear me okay?
Yes, sir.
All right. Looks like originally this was a show cause with parties not attending. It looks like Mr. Roll has attended the SMILE program. Ms. Dort, have you attended that program yet?
I was going to do the one on Monday from 6 to 8, March 3rd.
Okay. So we'll adjourn this matter then to a date after that. However, if you provide that, or if we get evidence that that has been completed, then that court date would be canceled. Any questions, ma'am?
Nope. Thank you.
I have
Sure,
a couple of questions that don't pertain to the SMILE program.
Well, I'll see if I can answer.
Okay. Victoria and I had an agreement that I would file, or I would claim Genevieve this year, and we would split that. I was kind of wondering if that was still a thing, or if she had claimed her.
All right. Well, I've got valuable court time. That is a matter not for the court.
Okay.
To deal with.
The other one. The other one
ahead.
would be about child support. I have no problem paying child support, but it says that I'm to pay it to Victoria. Either one of us have Genevieve. She was taken into, she's a ward of the state as of August 28th.
Okay. From the court, are you aware of that circumstance?
Yes, Your Honor. It appears that the court recently signed a reassignment UCSO to assign support to foster care given the circumstances.
Okay. I do see the Judge Mertz signed a new order on February 18th, so just recently, indicating that the recipient would be the agency who placed foster care.
Okay. And I mean, I guess in that matter, I feel like I shouldn't be the only one paying child support.
All right. Well, if you want to file a motion regarding support, that would be the way to do it. So you can contact your caseworker to discuss the situation too. Okay.
Okay. Thank you.
All right. Thank you. You're all set.
Thank you.
Oh, shit. That's going to be right in the middle of the mediation now.
The OTP. Mr. King, can you please unmute? Let me know if you can hear me okay.
Yes, I can hear you.
Thank you. And Mr. Blumberg, if you could please place your appearance on the record.
Certainly, Judge. Thank you. Elliot Blumberg on behalf of Ms. LeBeau. Judge, we're here today because my client had filed a request for a child support review. There had been no reviews done since 2018. Mr. King had been paying $322 a month during that period. The friend of the court required the parties to turn in updated financial information. Mr. King did not provide any information. There was a hearing on January 25th, and Mr. King again failed to appear for that proceeding. He's then filed an objection to the recommendation, which is now at $522. It's our position that his failure to provide the information, as well as his failure to appear, negates his ability to object to this recommendation. So we're asking that the friend of the court recommendation be put in place with the effective date of November 19th, 2024.
Thank you. Mr. King, you filed an objection to a child support recommendation. Is that correct?
Yeah.
All right. And did you provide any information so that recommendation could be prepared?
I did not understand what I was given, and as I told, I think Miss Shasta, was that I don't know if it came late or what was going on, but it seemed like the moment I opened it, I only had a week to fill it out and respond to it, and the date that I seen it might have been my mistake, but it looked like the court date was back in November, not January. That's why I didn't show up in January. But no, I did not fill anything out.
All right. So it looks like the recommendation itself went out January 7th. Mr. King did file his objection January 21st. My understanding is, though, he did not provide his updated any financial information, but I'll hear the specifics of your objection and we'll go from there. So, sir, what are your objections to the recommendation?
Well, from what I understood, it wanted to go all the way up to almost $1,100 a month. And I work construction and I have a lot of health issues. And currently right now I'm in and out of the doctors between a back doctor and a heart doctor. If at any point in time I get sick, like I didn't work at all last week, so there was no child support from last week. And at the rate that, according to what I read, at that rate, if I get sick and I'm off work for 3 to 6 months, then I'm going to fall way behind.
All right. Well, we can't play future predictors and guess if you're going to be off a certain number of months during a calculation. A calculation is based on what your recent employment has been like. Obviously, if there is a support ordered amount that is entered and then there is a change in circumstances that prevents somebody from earning their income, that is a reason to come back to the court to see if support should be on hold or if it should be reduced. But we can't just assume whether or not you're going to be sick in the future.
And I also have another child. She is 3 years old.
Okay. Friend of the court, were you aware of the additional child?
We were not, because he didn't provide information. Just based on his objection, he indicated that there was an additional child.
Okay. And then as to determining his pay, did you have information to assist you in that?
We did. We received an employer's disclosure indicating his year-to-date, his overtime that was indicated, and then his gross earnings from the prior year. So we inputted based on that information, which was $30 an hour by 40 hours, and then his $400 in weekly overtime, which was indicated on that disclosure.
Okay. Mr. Blumberg, does your client dispute that he does have an additional child?
He doesn't know. She's unaware of that.
All right, Mr. King, do you have custody of that child, or what's the situation with that child?
Yes, I do. I have custody of her.
Okay. Would you please raise your right hand? Mr. King, would you raise your right hand, and do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, Mr. King, so this is your opportunity then to let the court know and provide any testimony that you wish to provide regarding an additional child. So obviously the child in this case, other than this child, do you have any other children that are under 18 years of age?
No, I do not. I only have the two.
All right, so my question was, other than the child in this case, you do have one other child then under the age of 18, correct?
Yes.
Okay. Mr. Blumberg, do you wish to ask Mr. King any questions?
Well, I do, but I'm taken back by the fact that he hasn't provided the court with any of this information. I mean, this hearing probably would not have been necessary had he done what he was required to do. And I appreciate the fact that he's unrepresented, but that shouldn't alleviate him of his responsibilities to provide the friend of the court with the information. So, yeah, with that having been said, Mr. King, where do you live?
I live in Noblesville, Indiana.
And you have physical custody of another child?
Yes, I do.
And what's the child's name?
Scarlett.
And what's her date of birth?
10/28/21.
And how long have you had physical custody of that child?
Her entire life.
Does the mother have parenting time?
We are together. I'm married to her mother.
And so, given the health conditions that you've just described for the court, you're not able to support that child as well?
My wife does have a job, so there is a second income, but I am the main breadwinner or placeholder of my household.
You would agree, would you not, Mr. King, that you had not had any increase in your child support since 2018?
That is correct. I do believe that's when it was established.
Right. And you've made the exact same amount of money for the last 7 years?
No, it's increased on the year based on project, but it has increased.
I guess my question, sir, is you didn't inform the friend of the court of any increases in your income, did you?
No, I did not. I'm generally working throughout all their open hours. It's really hard on me to communicate with them.
Okay. Judge, I don't have any other questions.
All right, thank you. So based on the information before the court, the friend of the court has indicated that they did determine his income based on an employer disclosure form. So I'm not going to make any changes to income. There is an additional child of Mr. King. So we will add that child to the recommendation. So his objection is granted in part and denied in part. We will prepare a new recommendation based on him having one additional child. Any questions, Mr. Blumberg?
No, Judge, thank you.
Mr. King, any questions?
No.
All right, thank you both for appearing. That does conclude the matter. You may sign off.
You say I was good to go.
Yes, we have the parties on that guard. So you sign off, sir. All right, if you're present, you need to unmute.
Hi, Your Honor.
All right, it does appear that Ms. McCarrick is present. Looks like Mr. Huntley filed an objection to a support recommendation. And it does not appear that Mr. Huntley is present. Therefore, the court would dismiss his objection and the recommendation would go into effect. Any questions, Ms. McCarrick?
No, I just didn't understand why he is trying to petition the court for parenting time when he's had parenting time all these years. I've never denied Mr. Huntley to see his kids at all. He has always been able to see them, but he chooses not to see these kids at all. The only time he talks to his kids when my two older kids reach out to him. That's the only time that they contact or they have any contact with their dad is when they reach out to him. He doesn't contact me to see how they're doing or anything.
Hold on. All right, we're not here today on anything to do with parenting time. He filed an objection to a child support recommendation. I do see in there he mentioned parenting time, but if he wants to address parenting time, he would have to file a formal motion to address that.
Okay.
For today's purposes, I am dismissing his objection to the child support recommendation.
Okay.
All right, thank you. All set. You can sign off.
Thank you.
1DM, do you have the parties on that matter present?
I'm here, Your Honor.
I am here as well.
All right, thank you. Both parties are present. And sir, this is your objection to a child support recommendation, is that correct?
Yes, sir.
What is the basis of your objection?
So I have been in the process of I work out seasonally in the field. Installing and removing docks is what I've been doing. And that comes with like a lot of fluctuation in like overtime, where I had been working like 90 hours a week in the spring and like 70 in the fall, and then like 40 during the other times of the year. Sometimes less than 40 depending on the circumstance, but like that, ultimately the basis is I've been in the process of like transferring my role to being more of a consistent role so that I can be more consistent for our daughter as well. And so I am working with my employer to have a job that's more manufacturing, because that's what I do in the winter. Or like a more consistent in and out schedule so that I have that availability to Amara as well. So basically my objection is not necessarily that it shouldn't go up, but that like it going up from the $200 to the $1,200 a month based off of me making like $8,000 a month working in the field and getting commission and bonuses based off of those things isn't going to be something is available to me in like moving forward. So like my actual income will fluctuate somewhere around the 40 hours a week to the maybe 55 when that like when I do get overtime or when there is like a call for more work. And so I'm just trying to have it set on more of like a that kind of amount as opposed to it being based off of me making like 90 grand in the year, because that's not what my future years are going to look like at all.
All right, so you said you were kind of working towards a transition in
Like
your employment.
Yeah, we're in the process of it right now. Like I'm talking and I have been in conversation. Like last year was supposed to be my last year in the water. I talked to them about that last winter. I did that season partially because they really needed me to. And then like this is supposed to be the winter where I transition and don't keep doing that ultimately.
When do you expect that to happen?
I mean, I don't expect to go back into the water, or if I do have overtime, I don't expect it to exceed 60 hours ever in a week.
All right, so I guess I'm still confused. So you talked about transitioning into a different role. That hasn't happened yet, or it has happened?
So like part of it is like I brought to them the fact that we were doing this child support thing too, like as it was brought to my attention, and they're like trying to create a hybrid role where I am still help out in the field in the sense of like I still do work that's related to that, but I haven't a consistent in and out schedule as opposed to the schedule that I have now, which is I go in at 7 o'clock, and whenever the work is done or dark or whatever that ends up being, I drive back from the site and go home. if that makes sense. That's what my work has been, is I've been working remotely from the shop, going to sites and installing and removing dock.
Ms. Badgley, anything that you would like to say or any questions that you have?
No, I mean, I know his work situation, and I know in the wintertime, he makes significantly less money. But I don't know when if, like you said, I don't know when the transition is going to happen, but I know he'll work less if he does actually make that transition or not.
All right. And in front of the court, on the calculation of this matter, how was his income calculated?
Because he didn't provide any information, the employer disclosure was utilized, and we inputted based on his annual from 2023 and the quarterly wages for 2024 for that calculation.
All right. All right. So given that information, it does appear that the calculation was based on what the average work was. And certainly plenty of people have work that fluctuates. That's why they would look at a couple different years of income. It doesn't sound to me like this transition is officially done yet, or there is an official change in what the work is going to be. So if that is more, if that is shored up more in the future, and there is a specific figure that the court can look at as to what the employment is going to be moving forward, I can take another look at this matter and find that there is a change of circumstances that might warrant a change in the support. But based on what's presented today, I'm going to deny the objection. But I would indicate for you, sir, if you do formally make that transition to a different type of work with your employer, and you can have a nice, consistent idea of what that pay is, the court can take a look at making a change at that time.
Okay, I understand.
Thank you both for appearing. You're all set and can sign off.
Have a great night.
Yes.
Okay, is Mr. Ratliff present?
Can you hear me?
I can.
Yes.
All right, and this is, ma'am, this is your objection to a child support recommendation, is that correct?
Yes, sir, it is.
Okay, and what is the basis of your objection?
So on October 30th, me and my daughter had came in and we actually had seen with you. I don't even understand what actually happened, because at the time my daughter was currently residing with me. She had moved in with me on September 20th of 24. She lived with me until November of 23. November 23 of 24. And I'm just confused on when we left the courtroom. Lee was actually supposed to be paying child support for 101 overnights. On this paperwork, it says that I do not see her at all.
Who is she living with right now?
She is currently residing with her dad. She moved back to his house on November 23.
Okay. And how many overnights do you have her?
I would like to go back to the 50-50. Me and her have a good relationship. I talk to her every day. She wants to go 50-50. It's with our whole, how our stuff is set up, it's hard to say she's going to be here exactly 50-50. You know what I'm saying? Because she's almost 16. She is trying to get her driver's license and stuff, but at the end of the day, she does want to come home as much as she possibly can. This is like a back and forth thing that we're constantly going through with her. Like 1 minute she's living with him, then with me, and then with him. It's just that we're always doing this.
Mr. Ratliff, what do you think the appropriate number of overnights should be?
I honestly, I'm at a loss of words with her right now, because she does do this back and forth thing. And, I mean, I'm willing to do 50-50, but I would just like to be met or something.
Yeah, I'm willing to meet you in Greeley.
Well, I'm not making any, hold on, I'm not making any changes on your custody. I mean, if you guys want to file a motion on that, that's great. We're here today on a support issue. So we need to figure out what the appropriate number of overnights is for the support calculation. You guys want to split the overnights for the support calculation? Because it sounds like your daughter just bounces back and forth at will.
Yeah, I would like to do the 182.5 overnights.
Mr. Ratliff, do you think that's appropriate or not appropriate?
I mean, I guess it is what it is, but I know she's not gonna be there that much.
Well, if you don't have an agreement, then what we can do is take testimony and have a hearing on another day. If you guys have an agreement, that if not, we'll.
Because I'm tired of doing all this too, so. Even though she's here most of the time, that's fine.
So you're okay with the number of overnights support being calculated based on equal overnights?
Sure.
But then my concern is, what if that results in Mr. Ratliff having to pay support?
Well, being I've been paying support and had her most of her life anyway.
But isn't it true that he would only be paying support because she gets assistance through the state?
All right, so what we're going to do is we're going to shore this up and figure out how often the child is currently going to mom. So, Mr. Ratliff, the child is living with you. Is that correct?
Yes, and she has not been back to her mother since the day she came back.
No, but we've tried to make arrangements.
All right, so we're not going to interrupt each other. We're going to have everyone gets their chance to speak, but we're not going to just interrupt, okay? So, Mr. Ratliff, I'm trying to get the recent history from you. You were in court, it looks like back in October, I guess.
Yep.
And physical custody was granted to, well, at that time, physical custody was granted to the defendant, correct?
Yes. And that's the last order, it looks like.
Yes, and then she came back.
But now you're the one who actually has physical custody, is that correct?
Yes.
And how long have you had her in your care?
As Holly said, since the 23rd of November.
Okay. And how many overnights has she had since that time?
None.
Okay.
We have tried getting up there, but things just didn't work out that way. We did try to set up me taking her up there, but my vehicles are currently, as soon as we're done with court, I'm going to take one in to get fixed, so.
Do you anticipate some type of overnights happening?
Eventually, yeah, I do, because Treasure does want to see her mom, and she did ask me when I could take her up there again. So, and I told her as soon as the vehicles are fixed.
Is someone going to file a motion, or are you guys going to submit some new stipulated order that addresses what is actually happening right now?
I kind of thought that's what we were doing today, but I guess I was confused a little bit, so.
This is an objection to child support, nothing to do with parenting time, but we can, if you guys make an agreement, we can put it on the record.
Right, and I'm fine with the 50-50. Like I said, I just, you know. I just know it's not going to be that.
Sir, can I say something?
Sure.
I would really like to try to make it the 50-50. I'm more than willing to meet him in Grayling at any point that I can actually make it 50-50, because she does have a younger brother that likes to see her as well. Like, we've been trying to do this 50-50.
Well,
homeschooled.
I've opened up too many cans of worms here, and you guys have very limited time, and now we're going to delay everybody else's case who's present. This is simply a child support, an objection to a child support recommendation that granted 0 overnights with Miss Devitt. The information so far provided to the court is that since November, there have not been any overnights. Mr. Ratliff indicates that he would anticipate some type of overnights. So, sir, what do you think is going to be the average overnights that would be spent with mom in this case?
It's hard for me to say. That's more kind of on her. She has
her own schedule with her other son, and that she tries to get Treasure and him on the same day, so I don't ever know when any of that is.
So based on the information provided, I'm going to have a new child support recommendation prepared based on equal overnights.
Okay.
You guys aren't really following your current order, so, up to you guys to file a motion to address something if you wish, because right now the order is that the child's with mom, but you guys haven't been doing that for months. It's a very awkward and different situation, but based on the nonstop back and forth and changes, I am going to recommend that a new recommendation be prepared based on equal overnights. All right, thank you. You both are all set. Sign off.
Thanks.
41 DM. We have the parties on that matter present.
Yes, good morning, Your Honor. Jennifer Smith on behalf of Monica Smith, who is present with me in my office.
Elliot Blumberg on behalf of Joshua Smith, who has not been served with this post-judgment motion, but I'm here on his behalf. We can address it in spite of that.
Okay.
First, if I may address that, Your Honor, on December 20th, we provided this to Mr. Blumberg and via email and by first class mail. The proof of service in the file reflects the same. I anticipated I didn't get served with this because that's what we've been hearing throughout this entire case. So we did serve them with it. The friend of the court had submitted a request to my client for her to pay $200 to the defendant without any support, and we objected to that back on December 20th.
All right, so this is Mr. Blumberg, your client's request for healthcare expense?
Judge, I have reviewed Ms. Dusman-Coy's motion. If her client has paid in excess of what she's required to pay, we have no objection. But Ms. Dusman-Coy doesn't have the courtesy to reach out and try to resolve this matter. So if her client's entitled to it, we don't object to it.
Well, I got this labeled as Mr. Smith's request for healthcare expense payment.
You are correct.
It was, Your Honor, but then we had responded to that by saying that we did not have any support for the $200 request and that my client had expenses in excess of that. And so we had responded by saying that she had expenses that she had paid of $318.85, and then she had a $1,322.33 bill that she's been paying $60.05 every month on.
All right, so what I'm gonna do is set the matter for an evidentiary hearing for 1 hour. Obviously, if the two of you meet and reach an agreement, we won't need it. I mean, it seems like it's essentially a math problem as long as you provide your support to each other. But we don't really have time to address all that right now, so I will set it for an evidentiary hearing. And for 1 hour, are the parties available April 23rd?
At what time, Your Honor?
11 o'clock.
I'm checking my calendar.
That date and time work for my calendar, Your Honor, excuse me.
What's your time, Judge?
April 23rd at 11.
Okay, I have an evidentiary hearing with you in the afternoon. Yeah, I guess for an hour we can do it.
All right, so we'll set it for April 23rd at 11. I mean, really, it ultimately is just a math issue, as long as you guys have support. So I would hope that the two of you can exchange what you have and perhaps figure it out on your own. But if not, we'll have that hearing date set aside.
No, I share your view on that. Hopefully I can get the information. Thank you.
All right.
May I ask, Your Honor, please, that we have in the recommendation from yourself that the parties do exchange their support for the money that they claim, because we didn't receive that from the defendant.
All right, yes, I will add in what is now going to be new standard language about exchanging witness and exhibit lists 14 days prior, as well as providing the physical exhibits to the other party.
Thank you.
All right, parties on that matter present.
Good morning, Your Honor. Ravi Gurumurthy. I'm appearing on behalf of the plaintiff, Mr. Andrew Sigafus. We're both on Zoom, Judge.
Good morning, Your Honor. Martin Levois for Adriana Norman.
And it looks like Mr. Guru Murthy, this is your client's objection to a child support recommendation. Is that correct?
That is correct, Judge.
All right, and what is the objection?
Well, Judge, the objection is two-part. The number of overnights and what those overnights are. And based on the effective date, we'd have to look at what these parties did when this was first filed. I have the breakdown as to what occurred. So back in July, this was filed. From July 7th until August 30th, Andrew exercised 54 overnights and Adriana exercised 0 overnights. We mediated this matter. There was a stepped up increased parenting time for the defendant. So that was done September 30th. So from August 30th until October 2nd, Andrew exercised 76 overnights. Adriana exercised 6 overnights. We then mediated this in December, on December 6th, and we have a new schedule. But then between October 2nd and December 6th, Andrew had 49 overnights. Adriana had 17 overnights. After mediation, from starting in December up until current, Andrew exercises an average of about 16 overnights, and Adriana exercises an average of about 10 or 11 overnights, given on the months where there's one extra, the 31st day is in there. So I think based on that, and then when you add the holiday schedule, the overnights that I have Andrew at 204, Adriana at 161. So I don't know how the court wants to recalculate support based on how the effective date and where the stepped up parenting time was. So, and then the recommendation indicates 182.5 with an effective date of 7/9. I don't think the issue is the effective date. It's just it goes back and improperly calculates support, and then charges my client to pay support when he had the child, a majority of the overnights during that time frame.
All right, well, we certainly can do a couple of tiers if we can pin down the number of overnights. Mr. Lavoy, as to those figures and the argument, anything that you would like to say?
Your Honor, I don't know if my client agrees with those, but we were here a month ago or so, or a few weeks, and opposing party never showed up. I don't know why this just can't be referred to the front of the court, have these two individuals show up indicating what they have in terms of overnights, and let the front of the court calculate it. I thought that's what was happening, but apparently not.
Well, and Your Honor, I think that's fine. The problem is it was just improperly calculated, hence the objection, right? So it was referred back to front of the court, calculated by front of the court, but it's that tiered system of what those overnights were to where we were in December and what that schedule now is. I can certainly have Andrew stop at FOC with the breakdown of the overnights, the income, and what that looked like back in July to where it was stepped up in December, and have them tiered in that fashion, and that's totally
Yeah,
fine.
that's what should happen. That's what should happen. I agree, and I think Adriana can show up at the front of the court with her overnights, her wages. I think she had recently had a new employer, so I think she has given that information to the front of the court. But yeah, they could both go back there and have them recalculated properly according to the stepped up parenting.
I think what I'm going to do, though, is set the matter for a hearing in case we don't get an agreement. So I'm going to set the matter out for a hearing, have the parties and the parties can come to agreement together and council can review it. But if you guys get to an agreement as to what the overnights are, then we wouldn't need to have a hearing. But if you can't agree, then I think we have to have that hearing available. This is a hearing that we could do by Zoom.
So, Your Honor, my only question is, do you want the parties to stop at FOC for the stepped-up parenting time from July until December so we can tier those up? Because I don't think there's a dispute with what those overnights are. Then the issue would be, since December, based on the schedule that they're exercising, what that overnight is, because that's the more consistent since December.
Right. So what I would envision is doing 2 tiers. The first tier being from the date of filing until that change in December.
Okay.
And we can, they can agree on what those overnights are. And then we would plug that in, and then what the new overnights are moving forward after that date, and then do a second tier. So I don't need them necessarily to stop in. I'd rather have council exchange what they think the appropriate overnights are. If you guys don't agree, then we'll have a hearing. If you do agree, we'll just plug those numbers in and do a new recommendation.
Okay, we can do that. I will send Mr. Leroy those overnights and the dates that I have. He can confirm with his client. If we have an agreement, we'll send out an email to FOC with those overnights and get a new recommended order with the numbers. If we agree, we won't object. If we have an issue, we'll come back for a hearing.
Certainly, we will get the overnights into place. There still would be a recommended order that goes out. So if there are other issues that need to be dealt with, it could be objected to. Any issue with if I set this matter for April 30th at 11 o'clock for a hearing in case you can't get an agreement?
I am unavailable that day.
Okay. Then we're looking at May 14th at 11 o'clock.
I can do that one.
Make that. Andrew, are you available May 14th at 11? I didn't hear you.
Yes, that's fine.
Okay, we can do May 14th if it works with Mr. Leroy's schedule.
Okay. I'm sorry, sir, you got muted.
There you go. Sorry about that. Yep, that date's good for me.
All right, so we're going to go with May 14th at 11. I'll allow that one to be by Zoom, given the nature of the testimony. Certainly, hopefully, the parties can review those overnights, reach an agreement, submit that information to the front of the court, and then we'll prepare a new recommendation.
Thank you, Judge.
Thank you.
All right, thank you. We're all set. DM. We have the parties on that matter present.
Yes.
Yes, Your Honor.
Does appear both parties are present. This is Mr. Lopshire's objection to a child support recommendation. Sir, what is the basis of your objection?
The basis, Your Honor, is the fact that I'm in the military and I just moved. And based off of where I go, I make less money. My base pay remains the same, it remains unaffected, but my allowance for housing, which was calculated in the initial thing, has decreased significantly.
Okay, what kind of change have you had?
It is down by, I believe, $2,200-$2,300 a month. And then I also have incurred childcare fees for when I do have my children at $2,500 a month.
And when did you make that move, sir?
I actually just moved last week.
I gotta put a date on. So was it, what day do you think it was?
It was the 20th, Your Honor, of February. I check into my unit March 3rd, and that's when my pay will be affected.
And then your parenting time is over the summer, is that correct?
Yes, Your Honor.
Do you have some sort of documentation as to what your child care expense is going to be during that time frame?
I do not, Your Honor. I have to get with the base. The base won't give me any documentation until they approve the kids to be in there, and they don't approve it until a month before the child care is needed.
All right. That issue will have to probably be addressed once we know actually what those child care expenses are. If there is a change in your employment, though, I would grant your objection then in part. But the original recommendation, then, that was based on accurate information, just that now it has changed. Is that correct?
Yes, Your Honor.
Okay. So that one would be effective up until, looks like February 20th. And then we'll prepare a new recommendation for February 20th moving forward based on any change in the income for Mr. Lopshire. Sir, you need to provide that information to your caseworker so that new calculation can be made.
Your Honor, I also have
Go ahead.
I just had a question. I've been paying child support without a court order or a recommendation for the last year and a half, 2 years. And I was wondering if Julia and I worked out an agreement, could we just do that instead of waiting for the court's recommendation again?
Well, you guys got to file a motion if you want to try and deviate from support to some type of agreement. But we do run an issue of whether or not you should have credit, it sounds like. So you have been making payments?
Yes, Your Honor. I've been paying. It initially started at, I believe, $1,800 a month, and then it went down to $16, and then now it's sitting at, I believe, $13. And I spoke to Julia about it, and I'm willing to go back up to $15. It's just with the incurred costs.
So, Ms. Lopshire, is it accurate that you have been receiving some money towards support?
Yes, he has been giving money for support, but it's not accurate that I have agreed with the $1,500 going forward. We agreed that we were going to have the court decide what the child support was going to be.
All right, I just asked because if there's a credit amount that he's due, we need to make sure that that is dealt with. Because this order is going to be effective backdated, and then if he's been paying money in between that time frame, he needs to get that credit. So I'd ask that the parties work together to try and determine what that credit is. If you guys can't reach an agreement together, we can have an evidentiary hearing to determine that credit. But hopefully the two of you can kind of go through what's been paid and can come to an agreement as to how much he has paid you so far so that appropriate credit can be given. And again, if you can't agree to a term, then we'll have you both in court and we'll take testimony and figure out what that amount is. So we will prepare a new support recommendation that would be effective on February 20th based on changes in Mr. Lopshire's income. And then if he does start to incur childcare expenses, once we know what that amount is, then we could prepare a new support recommendation based on that information, but we need to have that information obviously first and confirmation that that is happening. Any questions, Mr. Lopshire?
No, I don't have any questions. Julie and I are very amicable. I feel like we can come to an agreement somewhere.
Ms. Lopshire, any questions?
Yeah, for the credits, what date are we looking back at? Just so I know how far to go back.
The support rec will have an effective date of September 9th, 2024.
Okay, thank you.
So what we need to determine is how much he's paid you since that date.
Okay.
What if I was paying before that date, Your Honor? Because I feel like I've been paying for about a year and a half, 2 years now.
That's a discussion for the two of you because that's outside of the time of the order. If she wants to give you a credit, you guys can have that discussion.
Thank you, Your Honor.
All right, thank you. Friend of the court, any questions regarding the court's recommendation?
No, if he could please submit the current pay stub so we can see the difference.
Sure.
I know he said he doesn't have that pay change until next month, but as soon as he has that, that'd be very helpful.
All right. Any issues with that, sir?
No, Your Honor.
All right. Thank you both for appearing. You're all set and can sign off.
Thank you.
Parties on that matter present.
Your Honor, the plaintiff is present via Zoom. I see her in the upper right-hand corner of my Zoom.
Yes, I'm here.
And I represent defendant father Lee Allen Barnes, and he is also present.
Okay. This was a status hearing to address entry of the final custody judgment. Counsel, where are we at?
I prepared the final judgment and the final uniform child support order and the final uniform child support order deviation. I came back from out of the country on Monday. And so this morning, after I made sure everything was correct, I sent an email to both parties, and I sent both parties each of the 3 documents for their electronic signature. So I have not been able to sign back in to see if both of them have signed electronically, but basically everything is mirroring the temporary order that was already in place. Nothing has changed, but for, I know on the record, I believe mother had expressed that she was fine. There was such a small amount of child support that would be due to her that she was fine with just deviating down to 0. So that is what is in the deviation addendum. And I can go over the deviation factors if the court wishes. I can also go over the judgment, the main points of the judgment.
Is the custody then the same as, I think you said the last order that was into place, that it would be, is it week on, week off?
Well, yes, it is a 50-50 parent. It's a joint legal custody, joint physical custody, 50-50 week on, week off schedule. So that has not changed, other than some things like I always put in a non-disparagement clause. I spelled out parenting time, and for routine parenting time, it's the week on, week off. I did put in there though that unless they the parties can agree in writing that the default holiday and vacation parenting time would be the Otsego County friend of the court model parenting time provision for holiday and vacation parenting time only, but they have the ability to deviate from anything as long as they do it in writing.
So as to the support, my understanding is there is some state assistance in this case.
There is, Your Honor. There, I believe the mom and or the child are on some sort of state assistance. So I guess that was my question. I deviated down to 0, and I guess my question is that allowable when you have state assistance?
We do not do that. No, we do have to have at least that medical amount that is part of the support.
That's fine.
So, Your Honor, I can talk with the front of the court and make that small amount. I believe the old amount was like $41 or something along those lines, but I'm not sure if that's the correct amount or not.
It's actually 20.
Go ahead, Lee. What were you saying?
I just called up there and paid it the other day, paid it in full, and it's only $28 a month is what the lady said at the front of the court.
So I can modify the uniform child support order and deviation addendum and resend it to the parties for their signatures to comport that.
Ms. Dunham, the agreements that you've heard stated, is that accurate?
Yes.
Okay, all right. And I do see it does in general mirror the temporary order with some standard provisions. So it sounds like that's going to be completed and submitted soon. What we'll do is we'll set a status conference date on this matter out, somewhere in the 30 to 60 day range, with the understanding that likely this is going to be submitted certainly before then. And if this is submitted and signed, then that hearing would be canceled.
And I'm going to be doing this as soon as we're off of the hearing. Do we need to take any proofs at this point, Your Honor?
Well, I think we did with the temporary order, but I'll just ask, I can ask Ms. Dunham and Mr. Barnes real quickly. Ms. Dunham, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, ma'am. And you've heard the terms regarding the parenting time agreement and holiday agreement. Is that what you are asking the court to do?
Yes.
So the two of you are sharing joint legal and joint physical custody with week on, week off parenting time. Is that correct?
That is correct.
And following the standard holiday schedule?
Yep.
All right. And you've reviewed that proposed judgment already then that has been prepared by counsel?
I was actually reading it. Or are you talking
Okay.
about the email she sent me?
Yes.
Okay, I didn't get a chance to read it all because I've been at work since 8 a.m., but I was in the process of reading it when the Zoom started.
So you've heard those terms and you think that the joint legal, joint physical, do you believe that is in the best interest of your child?
I do.
All right, thank you. Mr. Barnes, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And sir, are you also asking the court to adopt the order that would grant the two of you joint legal and joint physical custody?
Yes, Your Honor.
And you're going to do week on, week off parenting time, is that correct?
That is correct.
And do you believe this agreement is in the best interest of your child?
Yes.
All right, thank you.
You're welcome. Thank you.
All right, so as indicated, we'll set this matter for a date, a status conference date, but again, if the paperwork is submitted, then that date will be canceled.
And I thank you, Your Honor. I just have a quick question. I need to verify the employment information for both my client and for the opposing party. Lee, can you just give me the name of your employer one more time?
Kurt Kidder. And I have to fill out the paperwork because I got a raise because they were just testing me out at $15 an hour, and I didn't want to put that on my child, like on the filling out information about how much you make, because I knew it was just going to get raised in a couple weeks. So it went up to 18. So I have to fill it out now.
Okay, so you're making $18 an hour. How many hours a week? I just need it for paperwork. How many hours a week?
40.
40.
Yep.
Okay. And what is Kurt? Can you spell it again? K-U-R-T?
Yep. And then Kidder, K-I-D-D-E-R.
K-I-D-D-E-R. Okay. And Alexis, can you please give me the name of your employer one more time?
I work at Jim Warnig Chevrolet.
Jim W.
Yep, Jim Wernig, and then Chevrolet, like the vehicle.
Okay. And just because I have to put this in the paperwork, it is not going to make change child support from that $28. What is your hourly rate, ma'am?
$15.50.
$15.50. And is that 40 hours a week?
Yes.
Okay. Thank you. That's all I needed. Thank you so much.
You're welcome.
All right, thank you everyone for appearing. You're all set and can sign off.
Thank you, Your
Thank
Honor.
you.
Thank you so much, Your Honor.
We have the parties on that matter present.
James Saffel appearing on behalf
That's
of
called- Mr. Trevor, is that you?
Yes, I am here, and my attorney, Elliot Blumberg, asked me if we could dismiss this for a later date because he's unable to be, and he wasn't given any information on this mailed to him.
Okay, Mr. Saffel, anything that you'd like to say?
Well, I guess there wasn't notice sent to him because he was not the attorney on this matter. But I don't have any objection to resetting this to a later date.
Okay. All right, so we will renotice this then for the initial hearing on this matter in about 30 to 60 days.
Thank you, Your Honor.
Thank you,
All
Your
right,
Honor.
thank you. You're all set and may sign off. It does not appear that we have either party present. This is a friend of the court petition. Friend of the court, what is the status of this matter?
Your Honor, the defendant was incarcerated for some time. He has since been released, and we need to do a child support recommendation. However, we have not received any information from Mr. Stewart. And pursuant to new rules, we would need your input as to what we should use for his income.
Right. Do you have any information regarding any prior employment for Mr. Stewart?
Absolutely nothing.
All right, so at this time, I would be my recommendation that the court use minimum wage for Mr. Stewart. Anything additional?
Yes, sir.
All right, thank you. We'll take a brief break before the 10:30 matter.
No. That's not a good idea for her to be in here.
And if council can please place their appearances on the record.
Good morning again, Your Honor. Elliot Blumberg on behalf of the plaintiff is appearing via Zoom from my office.
Good morning, Your Honor. Travis Grote, appearing on behalf of Alexander Mayer, who is present via Zoom, Your Honor.
And Mr. Mayor, I just want to make sure that you're able to hear everybody. So if you could just please unmute.
Yeah, I can hear you. Yep.
All right. Thank you, sir. You can mute again. All right. This is an initial hearing regarding custody, parenting time, and support. Mr. Blumberg, as plaintiff's counsel, where are we at on this matter?
Well, Judge, the parties have sort of put into place a parenting time schedule, but ultimately the issues need to be resolved. Mr. Grote and I have had some preliminary discussions about going to mediation in the hope of resolving this, short of having a contested 3-hour evidentiary hearing. So maybe with the court's blessings, you can order us to mediation and hopefully we can resolve the issues of custody and parenting time.
All right. Thank you, Mr. Grote.
That is correct, Your Honor.
All right. So then we refer the parties to mediation. Are you guys going to do community mediation or an attorney?
I would hope that we could use an attorney mediator. I think that would be best.
I would agree.
All right. So then we won't refer to community mediation. We'll just indicate the parties are going to agree on a mediator and mediate the matter. Obviously, if that does not work or falls apart, feel free to contact the court and we'll get you in as soon as we can. But we will set a status conference date out a couple of months just to see where we're at. Okay.
Sounds good. Thank you.
Thank you, Your Honor. Have a good day.
Thank you. You too. On that matter, present.
Yes, Your Honor.
Yes.
Okay. We are here for a final hearing to determine where the parties are at, as well as the appropriate paperwork. Ms. Carson, as the plaintiff, do the two of you have an agreement, and is the paperwork ready to be complete?
Yes.
Okay. And it looks like you've submitted a proposed judgment. Is that correct?
Yes.
Okay. And Mr. Campbell, have you seen that document?
No, I have not, Your Honor.
Okay. Ma'am, did you provide him a copy?
I did not provide him a copy because he's so far out. I didn't mail anything to him, but we did have a virtual conversation over the phone and through Messenger on Facebook. I made sure before I submitted the order that he was okay with the amount of days and the time periods and stuff during the year if everything sounded good to him before I submitted the papers.
All right, so I will run through all of this with both of you then. Ms. Carson, I'll start with you. Would you please raise your right hand?
Yes.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, ma'am. So is it true that you're asking the court to enter an order that would grant the parties joint legal custody, and you would have the primary physical custody? Is that correct?
Yes.
And that Mr. Campbell would have parenting time on extended school breaks and summer vacation based on the Gaylord Public School calendar?
Yes.
It looks like you've calculated overnights to be approximately 266 with you and 99 with Mr. Campbell. Is that correct?
Yes.
And that's what the child support calculation was based off of. Is that correct?
I believe so. I think the child support order, it was like 100, but with, snow days, it can take out of the summer vacation and everything. So I averaged.
Okay. And the two of you have any agreements then on how transportation is going to happen and those kind of things?
We haven't really talked about transportation for like permanent ideas. I think we're just going based off of, who can afford it at that time and what would be easiest for transporting the children. Basically, we just communicate over Messenger to figure out who's going where.
Do you believe this agreement is in the best interest of the children?
Yes.
Thank you. Mr. Campbell, would you please raise your right hand?
Yes.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. And sir, are you also asking this court to enter an order that grants the two of you joint legal custody with primary physical custody to Ms. Carson?
Yes, Your Honor.
And then you would agree that parenting time with you, you would have the children on extended school breaks and on summer vacation based off the Gaylord Public School calendar?
Yes.
You also agree with a support calculation based on 266 overnights with Ms. Carson and 99 overnights with you?
Yes.
And do you believe this agreement is in the best interest of the children?
Yes, I do.
In front of the court, I know you've had a chance to look at this document. Are there any issues that we need to address with the parties?
The information that she was requesting was a review, and it does appear that there's new state assistance, so it seems as if that would be appropriate to have that done after it's entered.
All right, so then prepare a new support recommendation.
After, yeah.
Okay, right. All right, in front of the court, anything else you think we need to address for today's hearing?
No.
And Mr. Campbell, so you have not signed this document, but you're agreeing to those terms, is that correct?
Yes, Your Honor, I am.
All right, do I have permission to sign your name to that document?
Yes, Your Honor, you do.
Questions, Ms. Carson?
Not that I could think of at this time, other than the child support. Should we continue, because Dustin has been sending me money via PayPal, should we continue that or wait until I get, I think it's a card from the friend of the court?
We would probably want to address any balance in regards to what's been paid.
I have called Shasta previously about Dustin sending me money via PayPal. I just haven't gotten any documents about where I could report it to other than me just telling her verbally over the phone.
All right, I mean, there is an effective support order, correct? So is that the amount that he's paying you, or?
He wasn't in full at the beginning. He was having a hard time finding a job and, paying the support. But he just recently sent me the 800 a couple weeks ago, and prior to that he had sent 5.
Well, if he makes any payments to you, you gotta make sure that he's getting appropriate credit for it, so you gotta make sure you report that.
Yes.
If he doesn't make payments to you, it would just ultimately lead to him having some type of balance that he might have to deal with. So I would say have some further conversations with your caseworker on that matter. They might need to provide you some additional information too to get this judgment done. Was the judgment, so is this ready to go to the judge then?
I believe so.
Okay. All right. So then we'll send the judgment to the judge for signature.
She would need to sign as well. We can have it ready for her to pick up.
She's got, well, one spot at least.
Oh.
Which is good.
Okay. And then maybe the defendant could contact us to find out in regards to employment and for him then to make payments through the disbursement unit.
So, sir, you do need to reach out to the friend of the court to speak with your caseworker. We'll prepare a new support recommendation then based on this also. Any other questions, Ms. Carson or Mr. Campbell?
Just how do I get a hold of the friend of the court out there? I live in Washington State. I'm 3 hours difference between you guys.
All right, well, they're open 8 to 4:30, so that should give you plenty of time to make a call.
Okay.
And I just, is it just us go to front of the court? I don't know how to find it.
All right, do you have a pen handy?
I can get one, yes, sir.
All right.
Go ahead, sir.
989-731-7450.
Thank you very much.
All right, thank you both for appearing. That does conclude your matter.
Thank you.
We have the parties on that matter present.
Yes, Your Honor.
Yes, Your Honor.
All right, looks like we're here today on a motion to opt out of friend of the court services. Ms. Reach, would you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
All right, ma'am, I do have in front of me a signed advice of rights regarding friend of the court services. Looks like you signed that back on October 24th of 2024. Is that correct?
Yes.
Any questions regarding that form or the rights that you would give up by opting out?
No, Your Honor. We're all good.
Is it accurate that you do not receive public assistance?
Yes, that is accurate.
And is this agreement, did you reach this agreement voluntarily and without any undue influence?
Yes, I did.
And do you believe this is in the best interest of your child?
Yes, I do.
Thank you. Mr. Lonachek, would you please raise your right hand? You're muted.
Okay, that better? Sorry about that.
Yep. Would you please raise your right hand, and do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Sir, it looks like you also reviewed and signed this advice of rights form back on October 31st of 2024. Is that correct?
Correct.
Do you have any questions regarding that form?
I do not.
And is it accurate that you do not receive public assistance?
No. Yes, I don't receive any.
Thank you. And did you sign this document freely and voluntarily?
Yes,
And do you believe this is in the best interest of the child?
I do.
All right, well, given the testimony of the parties as well as their submission of the signed advice of rights, I would grant the motion to opt out of friend of the court services.
And this would support deviate to 0, Your Honor.
Yes, so you're asking that support also deviate to 0, is that correct?
Yes, that is correct. And yes, so going forward, support 0, any unpaid balance cease to exist.
You would also waive any amount that is owed to you, ma'am?
Yes.
All right. And again, you're making this decision freely and voluntarily?
Yes, I am.
And without the support, do you feel you can still adequately support the child?
Yes, I do.
All right, thank you. And Mr. Lonachek, you're also asking that we deviate to 0, is that correct?
Yes, Your Honor.
All right, thank you. So we will do both those things, deviate the support to 0, as well as enter the order allowing you to opt out. I guess 3 things, as well as then Ms. Reach would forgive any back amount owed to her. There may be fees to the state that are owed, Mr. Lonachek, so you still would be responsible for those, okay?
Yes, sir.
All right. Thank you both for appearing. You're all set and can sign off.
Thank you very much.
Thank you.
You bet.